Michael Shaw with Berkshire Hathaway Home Services, Real-Time Realty. Today I want to talk to you about when you cross over the line from being a realtor to being practicing law. Let's take an example. You have your client, they're the seller, and they want to stay after the close of escrow for 7 days. And they say, just make an addendum and say, seller to stay for 7 days after close of escrow. And you go ahead and do that. Escrow closes, no problem. But then what happens? Lots of things could go wrong. The sellers may decide 7 days is enough, we're going to stay 3 months. Who's going to be upset? Well, the buyer's going to be very upset then. And who they're going to complain about, which will probably be you for practicing law, making a contract with them, a lease, without being a lawyer. What else could go wrong? Well, maybe the buyer's properties the seller's property is destroyed somehow because in the house. Who has the insurance? Who was supposed to have the insurance for that? What happens if the house burns down? Whose fault was it? Who has insurance for it? Who's paying your utilities? There's lots of issues there. So, what can you do to solve some of these problems? Well, CAR has some forms you could use. One of them is called the Seller License to Remain in Possession Addendum, SIP for short. If you use that, it kind of protects yourself. It's a license agreement. The attorneys have made it to CAR, so now you're using that, you're going to be safe because you're just filling in the blanks there. If it's going to be longer than 30 days, then you're going to be using the residential lease after sale. And that's for something more than 60 days. These forms, this form is 5 pages long. So you can see if you just put down something lightly, it's not going to cover all the bases that the CAR form does. Not only that, in addition to the 5 pages, there's 5 additional pages they have, other disclosures that must be made when you're in a lease. If you just make a simple addendum, you're not going to be doing that. So you want to make sure you use the forms that are there. Now what happens if your sellers insist, I don't want to use one of those forms, I don't want something complicated, I just want you to put down there, seller to remain in possession for 7 days. If that happens, then you're going to have a disclaimer there. And what you should do is say, seller has asked that these words be used. I have recommended the seller talk to an attorney, and the seller is going against my advice to do that. Therefore, I'm putting this forward. Now you saved yourself from a lawsuit. So besides leasing, what else can happen? Lots of other times, your clients may ask you to do something that you may think is simple, and it may appear to be easy both to your clients and to you, but you'd actually be stepping over a line. Usually that happens when you are asked to create a contract. A contract is when two parties promise to do something for each other. Buying something like buying the furniture from the seller. The seller promises to pay money for that, and the seller promises to transfer the furniture over. You may make up a little contract for that. The seller says, let's just do this, something like that. You'd be practicing law. Once again, what could go wrong? Property is damaged, doesn't get transferred, the money doesn't get paid. Lots of issues are there too. So always have an attorney draw these things up. Don't you practice law. I wish you all the best of luck in this time of emergency and good health, and be well. Thank you.